Madam Chair, good morning. I want to say how disturbing it is, the number of children that are on these medications, and that we agree that that has to be a last resort for these children. What really concerned us the most, I think, in reviewing the report and gathering the information is 40% of the findings came down to lack of communication, whether it was between the doctors or whether it was the foster parent, the guardian with the school, or the caseworker, and the knowing that perhaps something else could be done for this child instead of putting that child on medication. I know that at the same time that this was going on, and unfortunately we were a little late out of the gate, we now have a statewide form for all the volunteers that specifically asks about medication and also tells the guardian, please talk to school, please talk to the foster parents about how the child's acting. Don't wait until we receive information that the child may or may not be on medication, because we know that that could very well change daily. We would welcome the opportunity to become the medical surrogates, remembering that we're not medical professionals, but many of our circuits have already contacted different psychologists or psychiatrists in their areas to volunteer their times to give us those second or third opinions. But also,
in most cases, parents aren't medical experts either, but they still advocate on behalf of their children.
Correct. And I think it's important that in any time, like Ms. Rosenberg said, the child is spoken to. I think it's imperative that when the court, whether it's through a parental consent or through a court order, that the court sees the child on a regular basis and not just every 6 months when that case happens to be called up, or when the parent consents, to see that parent, to have that judge do a colloquy with those parents so the parents really do understand this is what the medication, this is what the side effects are, instead of just signing a piece of paper. And also it's important that everybody knows all of the medications these children are on. I don't want anybody to get the misimpression that these children are just on 1 or 2 medications. Some of these children are on 6 or 7 medications, and one doctor prescribing some doesn't even talk to the doctor that's prescribing the others. So one other big step that we've taken, because in large part because of so many of these children are asked to give their own medical histories, because it is through a transport officer when they go to the doctor, is we're hoping by the beginning of November we have in place where our guardians can start transporting the children, because our guardians do have a lot of the information, and I know many of our guardians, though they are volunteers, would be more than happy to go to the doctor's appointments with these children and share whatever information the guardian has, because again, the information is only as good as that's what's given, and we really need to concentrate more on communicating. I know I'm probably the rookie in this area, but it's amazing how much can be done if we all really start concentrating on working together and communicating what we all know, instead of everybody so worried about the bureaucracy or their own boundaries.
I think those are excellent recommendations, and it's just it shocks your conscience to think of making the child in charge of communicating to the medical professional their medical history. My daughter is precocious, and but she's 10 years old. But I couldn't rely on her to communicate with the doctor to her medical history or medical needs. She might focus on the little cut that she got from the paper thing, but she would forget the tonsillectomy. So because it's the nature of a child to be that way. It's just shocking that we're doing this.
I mean, when I go to the doctor will ask me something, and 10 minutes later into the conversation, I'm like, oh, and there was also, this, where even as adults we forget. So I agree, it is outrageous that we think that children can give proper medical histories.
And then I'll take the opportunity to make the other point that if it was all in phys-ven, then the doctors would be able to look at and see what other drugs are being taken. So just have to make the point. Sorry. Okay.
Question.
Senator Wise and then Senator Rich.
The question is, are you saying that when you have a medical advocate that you think that the foster parent should go with the medical advocate to the doctor, so that they both go, so that there's 2 people involved because of the delivery of the medicine or whatever it is to the child, that they both hear it and maybe they have that conversation as they go along? Or are you just saying that the person who takes the child to the doctor's office would be the medical advocate?
Madam Chair. I think as many people that can attend that doctor's appointment as possible should go. I know many times a foster parent may not be able to go or the guardian may not be able to go, but it's imperative that they have that communication at least beforehand. Again, I think even the caseworker should go to the medical appointment if possible to give as much information and to receive as much information as possible from the medical doctor.
In your opinion, do you think it's unrealistic for the judges with the caseload that they have? Let's take Broward County. How many judges do you have that deal with these issues in the family courts? And how many kids do you have? I mean, if you are doing it, the caseload becomes so great, then the next thing that they're going to come here to us is say, we have to have more judges and because we're seeing the kids every week or whatever it is. How often you're talking about the judges seeing the child?
Madam Chair, I'm sorry. I would like to see that at least at the time that the child begins the medication, and then perhaps every 45 to 60 days, or give the medication time, whatever the medical professional says, side effects will start at this time, or we may see a change in behavior at this point. I'm not talking every week, but I think every 45, maybe 60 days, maybe 30 days, depending on the medication. And I understand the judge's caseload. I understand how busy they are, but these are children who, through no fault of their own, are in a system that now we're also giving them medication. So at some point, something's got to give, but it can't be the children that give.
Well, the side benefit to that is it might make the judge think twice about just saying, okay, signing off on. If he knows that he's now going to be responsible, or she knows she's going to now be responsible for, a colloquy with the parents, and then to follow up, maybe he's more inclined to say, why don't we try therapy? Work with that. Senator Rich?
Thank you, Madam Chair. Teresa, I'm just curious what the role of the guardian ad litem is in terms of trying to make sure that the law is being followed with regard to the obtaining the informed consent, or if it's not there, does the guardian ad litem say something? Where is it, or let the judge know, or what is the process?
The process is, when it's an informed consent issue, a lot of times what I found is we don't even know that the parent has given consent. A lot of times it may end up in the court file, it may not end up in the court file. When we go and visit and we find out that the child's on medication, we're a little bit behind the 8 ball at that point, but we are trying to work more closely with CLS, with the caseworker, about getting that notification. I'm hoping that, our guardians are only mandated to see the child once a month. I'm hoping that when they are on psychotropic medications, or maybe even some other issues, if they have bad educational issues, that we can at least follow that up with at least either another visit or at least a phone call to start doing that. But we need to get in there saying, where's the informed consent, or where's the court order? And one of the recommendations we would like to see is to make sure when it is an informed consent issue that everybody knows, and then bring the parents in, and in that informed consent or in that order, make sure that every single medication that child's on is on that informed consent or is in that court order, so we all know exactly what's going on. But you're right, we need to be in there making sure that procedure's followed.
Well, I have a problem because in the finding that is listed in the report, it says notification of all involved parties. How can the guardian ad litem not be considered an involved party? Why isn't the guardian ad litem specifically notified? And if not, then we need to add
Fix that. Yes, absolutely. It absolutely should be. It's very important. I agree. It's a fatal flaw, literally. Okay, so the other thing that I want to add for the record is the issue of informed consent. We cannot shrink from the fact that these children are in the system because their parents have failed them. So I hesitate to put all the weight on the competency of these failed parental units and their ability to provide informed consent for 2 reasons. Because let's just say this parent, has failed because they love the child, but they lack competency and they need with some additional supports to learn how to be an effective parent, and that's the best case scenario. The worst case scenario is you have an abusive, cruel, horrible person who's the parent of this child. In either case, this person is not the best person to decide necessarily what is the best thing for this child. Because if you just want your kids back and you think the state is telling you to medicate this child, what do? Do I say I don't think it's in the best interest? Do I even know it's not in the best interest? Or do I just sign the papers and say, so you can go through the whole colloquy of informed consent and the person is still going to say whatever it takes to get my kids back because I'm cruel and I want to abuse this kid and I want to get this kid back and teach him a lesson, or because I'm desperate and I want my child back even though I'm really incompetent. I love my child and I want to get my child back. So I'm going to say yes to whatever. That's why, in my opinion, the guardian ad litem is so important to really represent what is in the best interest of this child who's come into the system because his parents have failed him. So it's very important that we preserve the role of the guardian ad litem. So thank you for being here.
Thank